You have a brilliant idea. You've sketched it out, you've thought about it for weeks, and you're pretty sure it could make millions. But right now, you're terrified of two things: someone stealing it before you can launch, or spending thousands of dollars on a lawyer only to find out your idea can't even be patented. Here's three big questions all new inventors have. Can I patent it? What does it cost? And do I need a prototype? Today, we're going to strip away the confusing legal jargon. I'm going to show you exactly how to patent an idea from scratch, how much it actually costs, and the fastest way to get patent pending status. Plus, we're going to cover a major trap that is destroying new inventions right now, specifically involving AI. If you're new here, my name is Mark Trenner, and I'm a registered patent attorney. My job is to help inventors protect their inventions. Let's get right to it. Step one, is your idea actually patentable? Before you spend a single dollar, your idea has to clear three legal hurdles set by the patent office. It has to be useful, novel, and non-obvious. Useful is easy. Does it actually do something? Unless you invented a time machine that doesn't work, you usually pass this one. Novel means it has to be truly new. Nowhere else in the world can this exact thing exist in public view already. Non-obvious. This is where most inventors get tripped up. This means someone with ordinary skill in your industry wouldn't just look at your idea and say, well, yeah, that's just a common sense combination of two things that already exist. Now let's bust the single biggest myth in the invention world. You do not need a physical working prototype to get a patent. The patent office doesn't care if you've built it. They care if you can describe it. You just need to be able to explain your invention in writing and drawings so clearly that a person skilled in your field could build it themselves. If you can do that on paper, you can patent it. Now, we have to talk about AI because it's completely changing the patent landscape right now. I get asked this all the time. Can I use ChatGPT or any other AI tool to invent something and patent it? Or they ask me, can I list AI as my co-inventor? Under current law, the answer is a hard no to both of those. The patent office and the courts are very strict. Only a human being can be listed as an inventor. If you use AI as a tool to help you organize your ramblings into paragraphs or format data, that's usually going to be fine because that's not inventing. Although, side note here, this may be considered a public disclosure that could get you into trouble. So keep that in mind and beware. But if the AI actually conceived the core solution to the problem, that invention is not going to be patentable under the law. You need to be incredibly careful here about how much of your creative heavy lifting you delegate to AI, or you might find your application dead on arrival before it even gets reviewed. All right, step two, the prior art search. This is where you look to see if someone else beat you to the punch. Before you pay a patent attorney like me to do a professional search, I want you to do a free search yourself. Go to uspto.gov. Make sure it's the .gov, the official patent office website. There, I want you to search for features. For example, if you invented a spill-proof coffee mug for mountain bikers, don't just type that in. Search for things like container with a kinetic valve or a shock-absorbing lid. Features of your invention, what makes it new and unique. Now, if you find your exact idea already exists, congratulations, you just saved yourself some legal fees. But if you don't find that exists exactly already, that's your green light to take it to a patent attorney for a full search and evaluation. All right, here's the big one. Let's talk now about money. How much does a patent actually cost? To answer that, you need to understand the two different types of patent applications you can file. For most of the inventors who call my office, I recommend starting with a provisional patent application. Think of a provisional application as hitting the pause button. It gives you 12 months of legal protection under the phrase patent pending. During those 12 months, you can safely show your idea to investors, pitch it to companies, and test the market to see if people actually want to buy it. If the market says this is a winner, then you go spend the big money to upgrade to a non-provisional patent application. That's the one that gets examined and issues as a patent if it's accepted. But if the market says, no thanks, you just walk away and you're out only a fraction of the cost of a full patent filing. Look, filing a patent application is not a weekend DIY project. A poorly written provisional patent application, I think, is actually worse than no patent at all because it gives you a false sense of security while basically leaving the legal loopholes wide open. If you have an idea that you believe in and you're ready to protect it the right way, let's talk. Click the link in the description below to schedule a strategy session with me. There's no charge, no obligation. But we'll look into what you've got, map out a plan, and make sure your intellectual property is locked down tight. Don't let someone else profit off of your hard work. All right, make sure to like this video if it helped clear things up for you. And remember to subscribe for more inventor strategies. I'll see you in the next video.